Logged in. We'll get going in about a minute. Welcome, ladies and gentlemen, to COCA's presentation on the Buy Ontario Act. My name is Ted Dreyer. I am the chair of the board of directors of the Council of Ontario Construction Associations, which is generally known as COCA. COCA is a federation of 29 different construction associations. We are the voice of the non-residential construction industry at Queen's Park. COCA lobbies Queen's Park and the government in Ontario on subjects such as the WSIB, Skilled Trades Ontario, occupational health and safety, the Construction Act, and last but not least, the topic of today's presentation, which is public procurement. We are very fortunate today to have two presenters regarding the Buy Ontario Act. The first needs no introduction, but I'm going to do it anyway. It's Glenn Ackerley, who's presented for COCA on many occasions. Glenn is a lawyer at the law firm of Weir Folds, where he leads a deep bench of talented construction lawyers. In 2025, Glenn was awarded the Canadian Bar Association's Award of Excellence in Construction and Infrastructure Law. And he was also recently appointed as the legal counsel to the CCDC committee. So he is an excellent speaker on the subject. Also, we have Jeff Scourgy of Weir Folds, who is a partner there, and his practice is focused on procurement and contract drafting. So this very much falls within his wheelhouse. So without further ado, I'll turn it over to Glenn and Jeff. Thank you, guys.
Thanks, Ted, and good morning, everyone. So great to have you all here. As Ted said, and you'll see from the title slide, COCA thought it would be very helpful to have a session on the new Buy Ontario legislation that is really, really topical, given as we're going to get into that some of the measures we're going to talk about came into force this month, just June 1st. This has been a very, very recent development, and it affects the entire construction industry landscape in the public sector of construction across the province of Ontario. So understanding what it's about, what it's trying to do, how it works, what it's going to mean for you in the industry is really what we're going to deal with this morning in the session. So just to get us rolling, a bit of an agenda here. We'll first talk about what it is that we're talking about when we say Buy Ontario. What are these measures that have been introduced by the provincial government? And what's the framework, the legislative framework, the statute and the regulations and the directives that are all the pieces that form this picture? We're going to talk about one of the two important subject matters of the Buy Ontario framework, and that's capital infrastructure, because that's really what affects the industry, affects the construction industry. The second of the two topics, we'll just mention in passing, but that's really fleet vehicles. That's where public bodies are buying a number of vehicles for whatever purpose that they need them. A whole bunch of cars or a fleet of other types of vehicles that are going to be required to be sourced out of Ontario. We're not going to spend time talking about that aspect. We're going to focus on the capital infrastructure. And then we'll turn to talk about what these rules that we'll be describing mean for what you're going to see in both the procurement documents, the upfront documents, the requests for proposals and the requests for tenders that get issued by these public owners that you see every day, what it's going to mean in terms of what you'll see there and what you're going to have to respond with as a result of these new rules, and also the implications in contract drafting. What we're likely to see crop up in new contract language, again, falling out of these changes. So we'll talk a bit about that, and then some of the other consequences of the legislation. Along the way, if you have questions, please feel free to put them in the Q&A feature of the Zoom platform here. And we'll try and deal with them as we go. However, if the question relates to a topic we're going to get to, we'll just simply let you know that, and we'll get to it when get to that point in the program. So that's the agenda for this morning. We expect this is going to take 45 minutes to an hour or so, and then we'll stick around for questions at the end as well if there's more. But we certainly are open to discussion along the way if you do have questions. I want to make sure everybody understands what this is all about. So to set the stage for the topic, I think it's important to understand where we sit today. The very fact we're having a discussion promoting Buy Ontario is, of course, as a result of everything that's been going on in the last year and a half or so, driven by the changes in particular going on south of the border. We know a year ago, in April of last year, the US introduced all sorts of tariff measures. And to a large extent, I think what we're going to be seeing as we go through this was created as a reaction to that, those measures being implemented, which of course we Canadians felt were wholly unfair and unnecessary, and yet we faced them. So to some extent, I think this is a reactive policy, but what it's intended to do is in response to those US tariffs and as also supply chain disruption that happened during COVID and post-COVID. This is really an effort by the province of Ontario in conjunction with other provinces and the federal government to promote the Canadian marketplace of products and services and really try to increase the resilience of our provincial economy. And in fact, the act, which we're going to get into in a second, I'm going to just read you verbatim the purpose as it's set out in the act, because it really does help inform what we're talking about this morning. And it says the purpose of the act is to establish a framework for regulating procurement within the public sector in order to transform public sector procurement practices on the basis of principles of integrity and value for money, and with an aim to supporting economic development. So that's the first thing I had mentioned, and supply chain resilience, which is the second thing. And leverage public sector procurement as a means of promoting, protecting, and building Ontario's economy and businesses and safeguarding its supply chain. So that is the principles, those are the principles behind this framework, the Buy Ontario framework we're going to be talking about. It really is to promote the economy, yes, but also to help with the supply chain, trying to make it as local as possible and therefore somewhat less exposed to the whims of other trading partners who decide to impose tariffs, as we saw. And this is all part of a national trend. At the federal level, similarly, this past year, there's been the introduction of a policy framework for Buy Canadian, a preference for Canadian products wherever possible at the federal government level, purchasing level. And there may, in fact, be even legislation similar to what we see here that's introduced. But at the moment, there is a policy framework in place, and you can find that online and read about it. We're going to focus on the provincial Buy Ontario rather than the federal, but it is all part of a trend for sure. So what was the provincial response to these tariffs in terms of what they decided to introduce? Let's turn to that. So the first thing is, this is the idea of promoting Ontario businesses is not something new. There was, as far back as back in 2022, a Building Ontario Businesses Initiative Act, the BOBI Act, and that was designed to promote businesses, but it wasn't the same kind of procurement framework, legislative framework that we're going to be talking about today. But it was the early kind of form of promoting Ontario businesses. The other thing, though, that very much came into play last year, I alluded to this, is a series of countermeasures to combat the U.S. measures that were being introduced. And that, of course, is to push back against using materials or working with businesses that are from the U.S. that are coming up to Canada on the basis, of course, as we all appreciate, that if you're going to restrict our capability of trading with you in the U.S., and you're trying to put up these barriers to entry by throwing up tariffs, then we can do this, play the same game. And so as far back as March of last year, just after the change in government in the US, there was a procurement restriction policy put into place where preference was given to non-US, to Ontario and Canadian businesses as a matter of policy. So that PRP, the procurement restriction policy, was introduced last year, back in March. But then over the course of last year, more thought was given to developing other measures, other frameworks to protect Ontario businesses. And that ultimately led to the introduction of Bill 72, it was, at the end of last year, which is the Buy Ontario Act Public Sector Procurement 2025. And that, as I said, was introduced at the end of December. But the meat on the bones of that statute didn't come about until later, earlier this spring, a few months after the statute came into force. So the act itself, if you were to look up the statute online and read it, it doesn't have a lot of content. As I say, that the substance, the meat of it, came later. But the other thing that's quite interesting is that you won't see, when you talk about the public sector in that statute, you don't actually see municipalities mentioned. You think, well, hold on, aren't they part of the public sector? You would think that this all applies to them. But what they did in the statute is says that this statute applies to, and we'll get into more detail on this in the next slide, but to the public sector at large, and being government and government agencies and the broader public sector we'll talk about, and any other sector of the public sector, any other portion of the public sector that gets brought in through regulation. So sure enough, there's been one regulation passed under this statute, and that regulation brought in municipalities as being part of this plan. So it really is truly the broader public sector as well as the government and municipalities. And I'll spend a moment on that in a minute. But in terms of timing, you can see up here what ends up happening is we have the statute with the one regulation that brings in the municipalities, as I mentioned, and then a series of directives, because the statute authorizes the government through management board to issue directives to these public sectors that spell out what the rules are that they're supposed to follow. And there are two directives that have been issued, one for the broader public sector and one for municipalities. So there's two directives. This is important, as we'll see. And each applies to those separate areas of the public sector entities. And they were introduced, as you can see there on the slide, at different times. Mid-April is when the non-municipal directive rules came into effect. So ever since then, if you're a university or a hospital, a college, etc., or a government agency, you have to follow what the procurement directive by Ontario procurement directive says as of April. If you're a municipality, you're following the municipal by Ontario procurement directive, and it came into effect in phases, as you can see there. For fleet vehicles, I mentioned those earlier, it was mid-April, and then for capital infrastructure, construction projects, and we'll be talking about that this morning, that is a set of rules that came into force mid-May, and then just June 1st, the directive applied to local boards, transit authorities and those kind of local boards of municipalities and municipal services, utility corporations of a municipality, for example. Those came in, had to start to abide by the directive rules as of just the start of this month. So this is very recent, as I said at the outset, very recent in terms of developments, and people are still very much working on figuring out how to implement all these steps. So that's the sort of the timing of the introduction. Just a couple of points. As I said, there had been that earlier Building Ontario Businesses Initiative, or BOBI, I guess you could call it, statute that effectively got rolled into this program of directives and applies particularly what it was trying to achieve is now baked into the directive for the broader public sector. There are monetary thresholds as well that are set up in these directives as to when they'll apply. We'll get into that. But the idea is the rules kick in based on the value of the procurement. But remember, the legislation is quite broad. There's the one regulation that brings in municipalities. It's really done by directives. And those directives can just be issued and modified, amended very easily. So they don't have to go back to the legislature and pass new laws or pass new regulations. They can just change things, tweak things according to the directives. So that allows a lot more executive action being done quickly and some agility, I guess you could say, the way they've set it up. So I've touched on some of this already. Who does all of this apply to? I guess the starting point, to be clear on, is it doesn't apply to the private sector. So if you're a contractor working with developers or whatever, none of what we're talking about applies. This really just applies at the governmental and public sector level. And obviously, all the provincial government entities, ministries, Infrastructure Ontario, anybody you're working for, like building an LCBO store, for example, any government agency or government ministry is going to be subject to these directives. The next broad category is, as we call it, the broader public sector, and that's a definition under the Broader Public Sector Accountability Act. And that's hospitals, school boards, colleges, universities. It's that sector that receives government money. That's the next group. It's interesting at some of the rules, as we'll see later, for example, Ontario Power Generation, or the Independent Electricity System Operator, the IESO, you'll see them mentioned there. They're sort of half in, half out. Some rules apply to them, some don't for some reason. I think a lot of it has to do with availability of specialized equipment. But generally it's government, then it's the BPS, those public organizations that receive funding from the provincial government. And then the third category is the municipalities, local boards, municipal service corporations. And as I mentioned, they got brought in through the regulation. So if you're working for any of these types of public owners, you are going to be, as a contractor or a bidder, subjected to this new regime. And that's why we're here today, so that you can understand what we're looking at and what it's going to involve as you move forward.
Glenn, we just have a question. Somebody asked, will school boards be touched on? Are they part of this?
Yes. And so if you look at what the broader public sector is defined as including, and to find that definition, you look to the Broader Public Sector Accountability Act. That spells it all out and lists which hospitals, colleges, universities, and so on that are caught by this. School boards are within that same framework. They are caught. So if you're building schools for a district school board, that school board itself is going to be required to follow the rules we're going to get into next. All right. So yes, they're part of the BPS. As I said, it's a very, most entities of what you would consider to be the public sector in some form, colleges, universities, school boards, and so on, as compared to private sector developments. Or developers, you're doing industrial work, you're building a condo, an office tower. None of that work is covered by this. This is just really those who are involved in a way that involves public money being spent. It's the public money being used as a policy tool, the way it's spent, that we're talking about. And that policy, of course, is to promote Ontario businesses, Ontario contractors, and so on.
And Glenn, just before you move on, we have two other questions. One is that do these directives work in parallel with the Government of Ontario's broader public sector procurement directive? And then the other question is just, do these restrictions apply to foreign works?
So it's just works, it's procurements in Ontario by these Ontario based entities, to answer the second part. But working in parallel, yes. they're supposed to complement each other. So to the extent that the broader public sector directive that governs procurement in the broader public sector, I think you can consider that being supplemented or amended by these rules. So they do work hand in hand, because the BPS directive on procurement, of course, is really designed, or it spells out how to procure fairly from a process perspective and how to plan your procurement. These rules we're going to get into sit together with this in terms of, in addition to everything else the BPS directive spells out as far as rules to follow, there's also these additional rules you have to follow too. And it's very narrow, as we'll see, but the two will fit together, I think, reasonably well. So let's start to get into the details now. So I mentioned that there are two directives. So what that means is, if you're doing work for bidding to and then going to be doing work for a municipality, that municipality is required to follow the municipal by Ontario procurement directive. But if you're working for a university building some residence on campus, for example, that university as an entity has to follow the by Ontario procurement directive. And so there's these two directives. The good news is they're not terribly different one from the other. It's just that there's a few nuances and details that make them not identical. So you need to follow, or you need to appreciate that the owner that you're bidding to has certain specific rules to follow. Now, just focusing for a second on the non-municipal directive, the by Ontario procurement directive. I had mentioned the PRP, which was, the PRP was the one that required that you give preference to local businesses from last year. That, as I said, has kind of been baked into that directive, as well as the Building Ontario Businesses Initiative. Those are now subsumed within the by Ontario procurement directive, but they've not been brought into the municipal by Ontario procurement directive. So that's one of the distinctions. What it means in practice, as we'll see, is probably not a lot. It just means that there are requirements for public sector entities other than municipalities to expressly give preference to Ontario businesses where possible. There's some specific references to that don't exist in the municipal version of the directive. And also the other thing, as you can see there, the phase-in dates differed between the two approaches. But for our purposes, for the most part, they're pretty similar. There are some specific details. If you dig into it, I was looking the other day and found, for example, that if you're a public sector entity, again, I'll say like a university or a hospital, and you're looking for services, as long as the value's $140,000, you do not have to run or meet any kind of Ontario business preference requirement for hiring lawyers, just so you know. So you could hire lawyers from outside Ontario without consequence. So there's that. It gets down to that level of detail, what the exceptions are, and we'll talk about some of the key exceptions in a few minutes, but there's a lot of detail in these directives that you need to be aware of if you're a public owner that's required to follow them. So as I said, there are new requirements, very specific requirements for and rules to follow for construction projects, and that's what we're going to focus on, but also fleet vehicle acquisition. And that applies to both the municipal and non-municipal directives. So let's first, before we go on, one of the questions, and maybe Jeff, you can talk about this, is there's all these rules, and we're going to get into what the rules are in a moment. But what if they're not followed? Who cares? And it's interesting, the statute actually addresses that. So why don't you tell us, Jeff, about what it says about what remedies there are available for anyone who feels that the rules aren't being followed.
Yeah, and that's exactly right. This is one of the most, I would say, consequential sections of the statute from the perspective of contractors, bidders, right? Bidding on public sector projects. And essentially, this part of the statute, Section 11, creates broad immunity for the Crown and the public sector entities. So essentially, as we say there on the slide, there's no cause of action. So in other words, that's kind of legal speak for saying you can't sue for anything arising directly or indirectly from the enactment of this act, or any amendment or revocation of any regulation or directive. Glenn spoke about how they've already issued 2 directives. Any of that or anything done or not done in accordance with the act, there is no grounds to bring a lawsuit. So, and there's no remedy. So you cannot sue for damages, for compensation, for lost revenue or lost profit. So many of you who, of course, have experience bidding on projects may have seen or heard of or participated in situations where there was, a feeling from one disgruntled bidder that they shouldn't have been disqualified, or rather that their bid should have been selected as the winning bid, and they bring a lawsuit against the owner, and bring a claim for essentially lost revenue, lost profit from not being awarded the contract. The legislation has essentially barred those types of claims in respect of this statute. What does survive is that you can challenge a decision, but you have to do it through what's called judicial review. And there's also, you can still also make constitutional claims. We don't see that very often in the procurement context, but you could bring a claim for judicial review. So you could go to a court and say, I want this decision from this provincial entity or this broader public sector entity or this municipality. I want it overturned. But what you can't do is claim damages. And judicial review traditionally is a fairly high bar to meet. As an aside, you typically have to show some type of procedural unfairness, something like that. So I think the bottom line for contractors is, if the owner changes their procurement midstream to comply with this act, right, for instance, and we're going to be seeing a lot of that this year, you're not going to be able to bring a claim for damages. There's going to be no cost recovery. So I think the bottom line is that, I think contractors should try to adapt their approach, right? Get familiar with the act, with its rules, and focus on trying to comply with it, and, not assume that you're not going to be able to make challenges after the fact. I don't know, Glenn, if you'd add anything to that.
Well, I just point out another interesting little detail. This is the kind of trivia thing you can share as you're sitting around watching a FIFA Cup game. You can turn to your companions and say, you know what's cool about the Buy Ontario Act is the fact that preferring one business and based on the fact that they're local, for example, geographic location, is one of the things that's prohibited by a statute in Ontario called the Discriminatory Business Practices Act. And if you read that act, it actually says that buyers of construction, to put it simply, it's broader than this, but shouldn't be choosing who wins and who loses, who I'm going to deal with based on where they're from. In the same way, their race or religion. It's a way of you're not supposed to be discriminating who you do business with based on a bunch of factors, and where they come from, where the people you're doing business come from, is one of those practices, or one of those factors rather, that if you do that, you're being discriminatory. Well, that statute sits there on the books in Ontario. And you think about what's going on here, this is absolutely discriminatory. It's saying if you're not from Ontario, you're not going to be held at the same level as everybody who is from Ontario. You're discriminating between those within and outside Ontario in terms of businesses. So isn't that a violation? You might ask yourself, and the answer is probably you're right. This statute expressly deems what's going on in the statute, the preference for Ontario suppliers, as not being a violation of the Discriminatory Business Practices Act. So it's kind of cool. You've got a government saying the statute on the books of the law of Ontario that directly affects what we're doing doesn't affect what we're doing. And sort of it actually exempts itself, the legislation, from being the very violation in terms of a practice of another statute. So all of which, to sum up what Jeff was saying, is that what's going on here doesn't itself give rise to a cause of action. The only door is kind of open a crack is the fact that if a decision is made that potentially violates what the rules are, you might be able to go to court and get a court to set aside that decision, that award, in favor of you if you're the bidder, but you can never get damages for what happened. And that's the real issue.
And Glenn, just before we move on, somebody asked a question right on that point, which is how will enforcement against, say, dishonesty occur, if at all, and with no remedies, what chaos may likely occur? On the dishonesty point, that's interesting, and that's where, just to Glenn's point, that's the sort of thing where you may try to bring an application for judicial review. That's the type of thing you might try to pursue. But again, note that it is going to be challenging, and I'll just flag that in the statute, they specifically carve out, reference a whole series of types of legal actions and claims that can't be brought. And one of them, actually, they reference is bad faith, which is one of the typical ones you probably would have thought would be able to be brought. And that's exactly what this person's asking. That's the sort of something like dishonesty. They've even referenced that as not being a applicable grounds for making a claim.
The other thing that they, just on the dishonesty point, to some extent, the statute is express on this, and the directives certainly mention this, which is as we get into what's actually required, we haven't gotten into the rules yet. But when we get there, one of the things is information being provided by the bidders to the owner running the procurement about the degree of content, Ontario-based and Canadian-based content, in what's being supplied, the service materials being supplied. Well, that statement is being presented and to the owner. The owner is entitled to rely on it. And when you think about it, what that's really saying is, if it's a lie, if it's not true, then somebody else can't say, you, owner, shouldn't have relied on that. You should have done your own investigation. You can't trust everything everybody says to you. That kind of complaint sort of evaporates when the legislation itself and through the directive says you can rely on it. So if the person's lying to you, the information you're being given is false, it doesn't matter, because you're just entitled to take it at face value. So even that, as Jeff was saying, really, that kind of dishonesty doesn't form the basis of a claim. So that'll be very interesting, whether people just say, oh yeah, everything's great, I'm following the rules, here's all my Canadian content or Ontario content, and none of it's true, then another bidder wouldn't have any recourse. Now, the owner may have recourse, and we're going to get into that in a few minutes about what we may see in contracts as between the owner and the bidder who was making those statements. What kind of enforcement mechanisms are there? But more generally, it doesn't create a cause of action for a bidder to say the other bidder was lying when they said what they said. Okay, let's go on now and talk just quickly. I've mentioned this already. This applies to the broader public sector, not municipalities. Buried in the directive is sort of this the procurement restriction policy. The PRP has sort of been brought forward to say that you cannot. There's a strong prohibition, subject to certain carve-outs or exceptions, on using U.S. businesses, and that's defined. And basically, it's where the headquarters are in the U.S. and there's fewer than 250 employees in Canada. It's basically a U.S. business in Canada. You're not to use those businesses unless you can't avoid it. Basically, it's really the only viable source. The other carve out is at least if 90% of the staff who are providing the services are staff located in Canada, then that's okay. But the real objective is to avoid wherever possible using a US-based business. And if you really have to, you actually have to go seek permission. Now, another carve out, it's not on the slide, but another carve out too is if there's an existing vendor of record list that the owner has in place with a bunch of businesses, suppliers, contractors, whoever it is, listed there that's present right now, they can continue to use that list. But otherwise, it's strongly discouraged, and you're going to need approval if it's a major purchase from a US business. But as I said, this doesn't apply to the municipal directive. It's one of the differences between the municipal directive and the broader public sector directive.
Just briefly, we've got a question just on this topic. Somebody asked, what's to stop a US or outside of Ontario company from opening up a token office in Ontario? And I think you answered that. That you would have to make sure they're complying with this requirement if they're bidding on broader public sector or provincial projects.
Right. So there's a real push to exclude, and maybe this is a good point. I'll just pause. So to exclude U.S. businesses or resorting to U.S. businesses. So there's really two sides as I think about it. You should appreciate. That's part of the puzzle, is to avoid the use of U.S. businesses as defined, which is, as we said, headquarters and few staff in Canada. On the other hand, the other part of this whole framework is to promote the use of Ontario-based and Canadian-based businesses. So it's the two sides of the same coin. Avoid using U.S. businesses and promote the use of Ontario businesses. That's really what this piece is about. Now, let's zero in now on what the rules are, in particular about capital infrastructure. As I said, there's also fleet acquisition as part of these directives. We're not going to spend time on that. We're going to focus on the capital infrastructure because that's really where all the impact is on the industry in Ontario. So there's lots of definitions that you need to get your head around to understand what's going on here. We'll get into a few in a second, but the starting point is, what is capital infrastructure? And it's broader than just construction. It includes construction, but also FF&E. So if there's furnishings that if you're, for example, building a school and there's all the furnishings for the school being part of the contract also being acquired, that's included. And then I keep talking about fleets of vehicles. Well, for transit projects, for example, the light rail transit cars, those vehicles, the rolling stock, buses, those are included in capital infrastructure. So this whole category includes construction and FF&E and the rolling stock and so on for a transit project, subway project or light rail project. That's all part of capital infrastructure. What is excluded, you'll see there, is medical equipment, technology, operational F&E, where you're just acquiring furnishings as part of your normal operations. It's not tied together with a construction project. And routine maintenance and repairs, that kind of thing, isn't included unless it's part of a larger program of repairing, for example, HVAC equipment. That probably would be caught, but normal just maintenance, repair, and operations, MRO, wouldn't attract these rules. And then, as I said earlier on, OPG itself is exempted. So that's capital infrastructure. What are some of the other definitions? Well, there's key definitions beyond that that apply, construction being the main one that affects all of us here. And that, as you can see, is site prep, excavation, all sorts of aspects of construction. Meaning that if a public sector entity or municipality is procuring construction, the rules we're about to get into apply. Those rules apply. And so they have to follow the directive. And the focus, as we've been talking about throughout the presentation so far this morning, is on Ontario-made goods. And you see that that's defined as being originating in Ontario or manufactured, or over the majority of the costs are being incurred in Ontario. And a Canadian-made good is similarly defined. And then services are where the individuals are located. So if you're hiring consultants that are engineers, and those engineers are located in Ontario or Canada, that's what that constitutes an Ontario or Canadian service. So those, as we'll see, are important to have in mind because that's what ultimately is being promoted and being measured during the procurement. And when we get into it, those are the categories that will have to be singled out and described in what the owner who's doing the procurement wants in terms of information from bidders. So let's now dive into what these requirements actually call for. So the concept, and let's just start with the context of all this, is that as part of the bidding process, owners are going to ask bidders to provide what's called a domestic supply chain plan. And it sounds complicated, but what it's really getting at is for the major goods, which itself is a definition, that are part of what this project is that's out for tender. Whatever those major goods are, as a bidder, you're supposed to identify in your bid submission on a form, you're going to provide the value within your bid of the goods, the major goods, and their origin, where they're coming from. And that includes the subcontractors. So the starting point is what's supposed to happen is the owner says, here are the major components of the project. you, each bidder, each vendor, tell me where you're getting those things from and how much of the total bid price do those materials and services represent. And that percentage, when you add it up, is the important factor, as we'll see. So if you're building a road and all the aggregate is coming from a nearby pit and the asphalt is coming from a plant that's obviously within Ontario, and the labor is coming from workers in Ontario, I mean, it may be that the Ontario content for that project is 90%. There's almost nothing coming from outside Ontario. That's possible. So that's what I'm getting at. It's the components of the project have to be identified. And the major goods, as you see, there's structural materials, building envelope materials, the M&E systems like rooftop units, where are they coming from, and so on. And this plan then is really just I've seen one public owner set it up as an Excel spreadsheet where the items are listed and their source and their value. And of course, it's when you add it all up, it's got to be basically add up to the bid price that you're bidding. So what do you do with this information as an owner? So there, you get this information in. What difference does it make in terms of the approach to choosing who wins the contract? And there's a couple of options that are set out that are available to public owners to use in their procurement. And they're broken out into two categories. There's the evaluated approach, where the amount of content that's Ontario-based or Canadian-based gets factored in as part of the evaluation of the proposal or bid. And then we'll come to another approach in a second that's called the commitment approach. But the evaluated approach, and we won't get into the mathematical details necessarily, but basically there's for smaller procurements that are defined, there's one of the two evaluated approaches are available. For higher level procurements, there are two options available for the evaluated approach. But in each case, the concept is preference is given to the proponent, the bidder, who has a greater degree of content, Ontario-based content, than the other bidders. So the more you're providing to the project that's based in Ontario or Canada, the better you will rank or score in the evaluation. Now, at a simple level, one approach is just simply a 10% evaluation advantage for the bidder with the highest proportion of Ontario content. That's the blue box on the left side. What that means is that if I have 70% Ontario content and you have 60%, I then get a 10% advantage on my price, meaning I get a discount on my price as compared to your bid price. So you may have a lower bid price and my bid price is higher, but because I get an advantage, because I have the most Ontario content, I may actually beat you out. And I'll show you an example in a second of how that works. So that's one option. The other option, which is way more complicated, but I'm involved in a procurement right now where this is the approach that was taken. That involves, as part of a larger evaluation through a proposal call, that typically that's where you're going to see it, an RFP, where they have constructability and schedule and all these different, and experience and all these different measures being factored in to the overall evaluation. Part of the evaluation, 10% of the total evaluation score, has to be devoted to the domestic supply chain plan, the DSCP. And what happens there is the person with the most content, provided it meets certain certain thresholds, will get the most points for the DSCP portion of the overall evaluation. And by that means could beat out everybody else. So basically, it's up to the public sector entity on the evaluated approach to choose which method works best. For a complicated procurement, it's likely the green, you'll see in the diagram, the green approach, the part where a certain percentage of the total evaluation score gets assigned to be evaluated around the DSCP. And then the more straightforward 10% discount approach will be for more straightforward priced bids. And I'll give you an example of how it works. So with the price only evaluation, here's an example where bidder 1 was 100,000 and bidder 3 was 105,000. But because bidder 3 had greater Ontario content, 40% Ontario content versus only 25 for the bidder number 1, that bidder number 3's bid price gets notionally adjusted. And I want to underscore that. It's a fiction. They just get notionally adjusted to earn a 10% discount. So their bid price of 105 gets adjusted down to 94,500 because they get the benefit of this discount. And you'll see that that beats out bidder number 2 that was at 95,000. So bidder number 3 will win, except that it doesn't mean that's the price bidder number 3 enters into with the owner. Bidder number 3 enters into a contract at 105,000 because that's their bid price. So even though bidder number 2 was only 95,000, the lowest bidder of the 3, they lose out to a bidder that's in this case $10,000 more, but it's because bidder number 3 had a greater Ontario content. Okay, that's the way it works. So
and
you can
Glenn,
see that.
Sorry, I just want to flag for there's a whole lot of questions coming in, but we'll just wait until we walk through this, and then at the end of the explanation we can address. But I just wanted to acknowledge we're not ignoring the questions. Yeah.
No, I think it's important we lay this out, and then there'll be a bunch of questions. But I'm sure. But you can see what this means ultimately for the owner, the tendering calling authority, is that they're going to end up, whoever that is, the broader public sector entity, is going to end up paying more simply because one of the bidders has more Ontario content. So basically the public sector is promoting this government policy of Buy Ontario, but it's costing the taxpayers, the ratepayers, whoever funds that entity, to do so for the privilege of having more Ontario content. Because the bidder who wins in this case is going to enter into a contract for 105,000, and bidder number 2 ends up the lowest bidder, but the loser. And that's why you can see what Jeff told us about in terms of immunity from action. This is the kind of thing that a lot of people are going to be very unhappy about. Those who were the lowest bidder in this case, but then lost out because of content, aren't going to be happy with that result. And yet that's what this regime, this framework calls for. Now, the second one, I'll just take a moment, is a more sophisticated or complicated approach. And that's where I'll just take a moment to walk through it, where you'll see that the total score of bidder 1 on an evaluated basis, score out of 100, was 91. And bidder number 3 was only 84. But on the 10 points of the 100 points that are devoted to the plan, the DSCP plan, bidder number 3 did better. And that's because they would have had greater Canadian and Ontario content. So they scored a 6 out of 10, whereas the bidder with the highest score was only a 3 out of 10 because they had much less Ontario content, let's say. So then what happens if you look at their price, you see that the price of bidder number 3 is higher than the bidder number 1. And so they end up winning it. And one of the other constraints is just simply that both the bid price has to be within 10% of the lowest price. If you're going to give it to somebody higher than the lowest price, it's got to be no more than 10% higher. And the second thing is it's got to be no more than 10% longer in schedule, the number of days if schedule becomes a factor. So what they're saying, okay, we're going to award it to not necessarily the best scored bidder in other categories, but we're going to give it to the one with the highest score of Canadian or Ontario content, provided that it's no more than 10% higher in price and no more than 10% longer in time. So that's a very complicated one. But as I say, I've got one right now where that's what's being used, and we'll see how that plays out. So I'm going to go on in a moment to the commitment approach, but maybe we can pause, Jeff, for questions.
Yeah. So, I mean, one is more just a comment. The individual says they agree with the directive, but they're noting that it'll probably put, anywhere up to a 25% markup on bids to control for this. And they note that in some markets, Ontario or Canadian-made options may be more expensive. And I think that's exactly right. That's exactly what Glenn, you're noting. In that the first example, you can see how that would actually absolutely could end up with an increase in price. Now, here's another good question. What about the markup on the material from the bidder? Is that to be included in the cost of the material?
That's a great question.
Yeah.
I think the source, it's more the underlying source of the material that's the focus. Is the material coming from, within Ontario or Canada or somewhere else? Before the contractor's own markup. I think when you break down the value, it strikes me, and I haven't seen it one way or the other, but it just occurs to me that when you're talking about the value of the material, it's the material cost itself. The fact that the contractor takes that cost and marks it up as part of their bid price, that cost is a local cost because that markup is covering the costs of operating, presumably in Ontario on the project. So, or within Canada. So I think it's more focusing on the source of the material and what portion of the total value of the bid is, does that material itself represent?
Another one, how far down the supply chain do the subcontractors have to be from Ontario? For example, if an Ontario subcontractor imports a large piece of equipment from the USA, how would that work?
Well, the bidder who's submitting this plan to the owner has to answer for everything that's coming to that project job site. So that will mean that the bidding contractor will have to understand from its, for example, mechanical subcontractors, how much of what the mechanical subcontractor is providing is coming from the US or anywhere else. Because again, the plan is focused on less where other things are coming from and more about how much is coming from Ontario. Presumably the part that's not coming from Ontario is coming from somewhere else. So if there's a requirement that, and we're going to come to this in a second with the commitment approach, if you're being assessed what percentage is Ontario, that's the key. So if a big high value item is coming from outside Ontario, that may skew it against your success because a greater proportion of your bid price is non-Ontario based or sourced.
We have a question. What proof is required to be submitted?
And so we might come back to that in more detail. So we can pause on it for a moment. I did say that it's not proof, it's a statement. It's the term that's being used as an attestation. You basically say, it's like filing your tax return, and on the form itself, it says, do you say all this is true? Yes, I do. And you hand it in. The proof that sits behind what you're saying is, interestingly, a second question. The owner is entitled to rely on the statement of what you say is true. The policing of that truth, or whether it's actually being dishonest, what you're saying, is something we'll get into in a moment.
Yeah, and there's a few other questions I think we'll hold on. The last one I think before moving on we could address here is one I really like. It's why would the public entities, through their drawings and specifications, not specify Ontario and Canadian goods and services so that all contractors are bidding to and automatically abiding by the spirit of the Act?
Well, that's what I think ultimately that may very well be if this whole thing doesn't take a left turn somewhere along the way, and CUSMA gets renegotiated and all this evaporates, this sort of reaction to the US, who knows what the future of this holds. But to the extent it takes hold and becomes a real thing, then I suspect you're going to see a lot of that the source, rather than putting it on contractors to source Ontario sources of materials and equipment and so on, you'll just have the designers themselves specifying at the outset types of materials and equipment that already provide Ontario content. I think that's a good question, and I can see that evolving, certainly.
Yeah.
So let me talk for a moment now about the commitment approach, just mindful of the time here. So this is an alternative. The evaluated approach is one option. The commitment approach is a second option. And what is that? Well, it's a different way of tackling the same kind of objective of promoting Ontario supplies. But in this case, it comes down to the owner doing the homework and saying, we've looked at the marketplace, we've decided that at least X% of this project's content, services and materials and equipment and so on, should be Ontario or Canadian sourced. And that becomes specified, that percentage, that commitment threshold, gets specified in the procurement document. So in the plan, in the DSCP plan that gets submitted with the bid, each bidder will lay out, as I said before, the source and the value. And if you add it all up, it should exceed the percentage. So let's say that the market testing and everything else that's done at the start of the procurement process by the owner suggests that at least 51% of the content can be and should be Ontario sourced. That's what will be in the document. And then the plan has to respond and meet that test. If not, it fails and you'll be rejected. The bid will not proceed because you haven't met the minimum threshold. So that's an alternative approach. And I've seen a lot of municipalities in particular decide to, rather than the evaluated approach I talked about, is to take this because it's a bit clearer. You establish what the percentage required to be met is upfront, put it in the documents, and then bidders have to meet that percentage as part of their supply package. Now, how do you establish it is an interesting question. And the guidance in the directive is that they've got to do some markets research and basically they have to be satisfied that it's achievable, but it best promotes it maximizes, use that word, the Ontario sourcing of materials. So using this approach, they'll say, yes, we want at least 60% of it to be local, and every bidder says, yeah, we can meet that, and that becomes the plan. Now, again, we have all the questions of what if it turns out it's not true, and the bidder is not going to source 60%, it's something different, something less. That we'll get into in a moment. But this is the other approach, the commitment approach. We could pause there before we go on to the bid documents you're going to talk about, Jeff. If there's any more questions.
Yeah, there are. There's a couple questions on the major goods. I'll try to maybe just summarize them all into a single question. I think the general question from the audience, from some members in the audience, is just what defines a major good? What's deemed to be a major good? One person says, well, for instance, the windows, how do you, is that broken down into the installation, the supply? Just generally, I think there's just a bit of questioning around what is a major good.
And so it's a great question. And we've talked, I know COCA's spoken to government officials about that very question. And as I said at the outset, this is all very new. And these questions that are being asked are really good questions. But, today and similar questions been asked by others. And it really is, this is not very comforting, I suppose, but it is a work in progress. And I think the government recognizes that some of these questions about what the major goods are on a particular project, what we mean by it, what we're concerned about, is it the glazing itself that we're really focused on? Like, what are the components? That list of major goods is something that I think is still, as I understand it, in development. And so we're going to have to see how some of that plays out. Right now, there's a lot of kind of figuring this stuff out in the dark that's going on, trying to make your way through some of these rules and try to honor them. Like I said, the good news is, Jeff underscored earlier, if there's a good faith attempt to meet these requirements and it's not followed exactly as intended, at least nobody can sue over it. You should have done it this way, and now it's that way, and I've suffered damages, and I should have won. That doesn't get you very far because of that immunity clause, if you will. So, but yes, I think some of these questions, I wish I had better answers, but it really is such early days that a lot of this major good definition, for example, about the components of a project remain a little bit unclear. I see that there is a question as well about timing and transition. And about a hospital project that's calling for tenders for some of the trades still, and our contract was signed in December. Are we bound by the act? I mean, the procurement that we're talking about here is at the prime contract level. So if that contract's already in place, then the act says this applies to procurements of contracts from the point mid-April, beginning of June, whatever the transition date is, the effective date, from that point onwards. So I don't think if you've got a contract in place, but you're still in the process of procuring materials under that contract, then the fact that, is that part of a larger plan and so on really doesn't come into play because there wasn't a supply chain plan in the first place at the time of procurement of that contract that you're trying to honor and comply with. So let's talk about bid documents next before we move towards the end here, Jeff.
Yeah. Well, and this touches on some of the questions as well. I think, you know, what we just wanted to flag were kind of putting on your radar in terms of what to expect, right? And I think there's a wide variety of scenarios. So first is nothing. I think at least in the short term, I think some owners, you know, particularly probably smaller municipalities, maybe local boards, they may not have updated their procurement documents yet to reflect the Buy Ontario requirements, just because they don't have time, they don't have the internal support or knowledge. So you might see that, right? And that's where, you know, as a bidder, you may want to perhaps flag to owners proactively during the question period, to avoid complications post award, right? It's if you can flag it early, better, you know, better to bring it to the fore and maybe put it on the owner's radar that this is a mandatory requirement they have to comply with, as opposed to just letting it sit and then maybe creating a kind of post-award debacle where somebody raises an issue and and it's brought to the ownership team, their attention after the fact. Another is incorrect structures, right? Some, as Glenn noted, this is early days. It's some parts of it are actually relatively complicated. So we may see some owners just, you know, not applying the wrong evaluation methods, using, you know, misinterpreting the thresholds, which options are available to them. So again, I think just reading the procurement documents carefully, and again, I think the recommendation would be trying to raise errors or ambiguities early through the Q&A period of your bid process is likely the most prudent approach. And then you might see, of course, the third scenario, which is the one we hope for, is just properly structured processes, right? Well implemented procurement documents that will hopefully include clear explanations and outlines of what approach is being taken and how you're supposed to comply with it. So I think bottom line, the takeaway is regardless of what scenario you encounter, I think it's just important appreciating the underlying obligations exist. And so you just want to kind of set yourself up now to understand the act, how it works, and you know, just getting ready to be filling out that supply chain documentation, tracking information, you know, getting ready to understand how to fill out a DSCP, and just getting familiar with it. So I think that's what you're going to start seeing, and we'll also talk about post bid issues as well, because and that touches on a lot of the questions.
Yeah, yeah. Let's keep going, and then I think we can do at the end a final sort of run through the outstanding questions, make sure everybody's questions have been addressed, even if the answer is we don't know. We'll see, because in some cases that's going to be the answer. So the next topic I can just quickly run through is some of the finessing, the fine tuning that recognizes this system we've been talking about this morning is going to have some exceptions, going to have some situations where it doesn't really work that well. What do you do as an alternative? And some of that is, at least some of it, is contemplated in the directives. So, for example, and you'll see in the middle there, value for money exclusion. If it turns out that you do an assessment and realize there is no way we can afford to actually honor these rules, implement them, because we will be paying greater than 25% that beyond what we would have paid if none of these rules existed, then you can get an exemption. But you need to get approval to be exempted, and it's on a case-by-case basis. You can't just say, it's going to be too much, forget it, I'm not going to bother. There's more rigor around getting that approval. Another thing that applies not to municipalities, but to the broader public sector and government is that there's still, and this is being more complicated RFPs, scoring proposals for as we've seen in procurement, sometimes there's societal benefits that are produced by hiring, for example, indigenous, incorporating indigenous labor, things like that. Those kind of social policies are in procurements. That's still part of the directive. It's contemplated on the non-municipal side, at least. And then if, as I said, it's just simply not feasible for some reason to run this process, there are exit doors, alternative methods you might propose that you need approval to do in place of what we've talked about today. The other thing too is that sometimes the federal funding that's attached to the project may have requirements that conflict with anything that we've talked about today, any of these plans, in which case the federal funding would provide you an exemption, that situation. They don't want to undermine the source of the money by imposing rules that somehow deprive you of that funding. So it's important to have the pieces fit together. So if there's some kind of conflict, then you get exempted from this process by virtue of some other federal level funding requirement that it would run into. So I think those are, the point here is just when you do a deeper dive into the rules, you see that there are aspects that are recognized as being unachievable. You can't do it because of funding, because it's there's just no way of accomplishing what the goal is. And so there is the ability to get exceptions or exemptions, but it's all very regulated. You can't just go ahead and do it because you don't want to bother with this. So let's talk about the contracting side. Maybe Jeff, you can walk us through what are the kinds of things we're starting to see and are likely to see in contracts in this new environment, the Buy Ontario environment.
Yeah, and a lot of questions have come in on this, and because it's a good topic, and there's a lot of questions I'm seeing here about, well, it's you're basically just supposed to trust that somebody's going to follow their plan. What's the actual repercussions of not following it? What's the reality post procurement, post bid award? And that's where we get into the contract piece of it. And it's an important structural point to understand. And that's that the Buy Ontario Act and its directives are imposing obligations on the public sector entities, but they're not prescribing specific contractual enforcement mechanisms against contractors, right? You won't see any section in the statute that says, and if the contractor fails to deliver the domestic content it committed to the owner, then the owner may do X, Y, or Z, right? There's nothing like that. But owners, on the other hand, are expected to comply with the act. So it's some say it's a gap. It's just the reality of the statute. So I think what you're going to see, we're already seeing this, is owners going to try to address this contractually. And so they're going to put provisions in their contracts that deal with this one way or another. And what are a few examples? So I think one example will be something like representations and warranties, right? You may see in the contract provisions that state that the contractor is providing a representation and warranty that the information in their DSCP is true and accurate, right? And that the goods identified as Ontario made or Canadian made will actually be provided and will meet those definitions. And meaning that failure to do that would be a breach of a representation and warranty. It would be a serious contractual breach that could give the owner remedies such as termination or a lawsuit for damages. You might see other things like holdbacks or retentions, right? Owners may try to structure a provision of the contract price as some sort of monetary retention that would be retained until there's some sort of verification process that the actual domestic content has been provided and supplied. You might see indemnities, right? So an indemnity that says the contractor will have to reimburse the owner if the owner suffers any damages or costs as a result of the contractor not complying with its plan, right? Not providing the domestic content. One thing I think you'll probably see a lot of is audit rights and record keeping documentation provisions. And that's because the owners, the public entities themselves, may get essentially audited by the minister. So they're subject to kind of compliance checks under the statute. And so they may want to reserve the ability in their contracts to say that if there's a compliance check on us, you are going to have to put forward the documentation and information and records to support your plan, and that you've been providing the Canadian and Ontario content that you represented you would provide at the bid stage. So those are some of the things we might see. I think, practical point again for contractors is read your contracts. I think what we're going to see things kind of all over the map. Again, something like a monetary retention or holdback, that could have a meaningful cash flow impact, right? So that's something you'd want to look at. So I think just carefully reading your contracts, and maybe we'll get to kind of a market standard in a year or two, but I think for the time being, we're going to see a lot of different approaches. Glenn, anything you'd add on that score?
No, I think it's just your last point is the important one, and I've been mentioning this too, which is we're going to see things develop over time to address these contractual enforcement tools. We're going to see different techniques used. But in the background is the principle that at the end of the day, well, there's an obligation, or owners are obliged to procure, to the largest extent possible, goods and services Ontario and Canadian based. If a provider of, or the party working on the contract says they're going to do it and doesn't, what are the damages that the owner suffers? Forget about the fact there's no claim by others that's available, the other bidders who said, as we talked about earlier, who may say that the bidder who won the contract was lying about the source. Forget that for a moment. Just what are the damages the owner suffers? And really that's the important next piece. We're getting very near the end, and then we'll open it up to the final questions. But if you look at the enforcement of the rules that we've been talking about, it really rests with the government, right? So maybe Jeff, just walk us through where the real teeth of enforcement is found.
Yeah, that's right. It's the minister who enforces this statute against public entities, right? And then owners are going to push those obligations downstream through the contract. At least that's what we're expecting. So the one critical piece is what I already touched on, the compliance reviews. So the minister can require a compliance review of a public sector entity, and basically a designated reviewer will conduct what is essentially an audit. And there's mandatory cooperation that the public sector entity has to provide its records and information, and a report is then prepared for the minister. And then the question is, well, what happens after that review? Well, the minister they can publish the findings. So there's kind of a reputational naming and shaming there, or they could direct corrective action. So they could issue some type of order actually directing the public sector entity to correct the issue. So again, I just think that the practical implication for the contractors is that owners are going to want to be able to show compliance in their procurements, right? The DSCP, evaluation, documentation. Contractor materials, right? Their plans, their attestations, any of their records may get pulled into the audit from contractual audit provisions. And so I think that's where documentation and record keeping matters.
And ultimately, the real stick that the government holds. Remember, all of this is the broader public sector, and that is subject to or dependent on public funding. So if a particular broader public sector entity simply disregarded these rules and went about their business not following what was required by the directive, then the government could, as a last resort remedy, pull the funding. And that's spelled out in the statute and in the directive, that if you do not comply, there is a risk of withholding funding or denying funding to that organization. So that's really where the enforcement comes from. It's the same mechanism. If you were to look years ago, I think it was back in 2010, when the Broader Public Sector Accountability Act came in, it was the same thing. Immunity from the outside world, bringing lawsuits and so on, but the government very much had the power to take measures to police the behavior of the broader public sector entity by withholding funding. And so that's really where ultimately, if somebody wasn't following the rules, the consequences may flow. So why don't we wrap up, Jeff, with the key takeaways? We can just walk through some of these we put up here, and then we'll open up to some of the questions as we wrap up here.
I think the bottom line is, and this goes to timing, is the act is in force. The directives are live. There's no kind of staged grandfathering, right? That's passed now. If the one directive came into force in phases, but we're now live, so to speak, with this act. So it's in force. I think you're going to expect to see these plans in public sector bids, right? So you're gonna want to, especially on the first few, get comfortable filling these out, building sourcing documentation into your processes now, working with your supply chain partners, right, subcontractors and suppliers, keeping those lines of communication open during the bid process for them to support you where needed. And I think that will be important, right? Asking for information from your subs will be important as well. As we touched on, anticipate new contractual obligations. Again, we think this is probably for the near future going to be all over the map. You might see all sorts of different provisions. I see somebody asked a question that they've already seen on a contract they're bidding on, liquidated damages in their contract associated with the act. So that's exactly what we're talking about. We're going to see all sorts of things like that. So yet another reason to be reviewing your contracts carefully, and monitor for updates as well. Like this act, as Glenn explained at the beginning with the timeline, things kind of came into force pretty quickly. So it's not out of the realm of possibility that we might see more directives, amendments, regulations. We know there's, as Glenn noted, there's international negotiations going on, trade negotiations with Kuzma that some of that might impact this. So, just keeping your ear open for any updates. And yes, as I think people have already picked up on, judging from some of the comments in the chat and the Q&A, that these requirements are administratively onerous. And so it's just all the more reason to be up to date on it, which is why attending something like this is good. And just making sure your teams are, aware and that you kind of hop on these requirements quickly once you get the bid document and go through it and understand what is being asked of. So those are our key takeaways.
Yeah, let's just in the final few minutes buzz through some of these questions that we didn't get to, some of which we might have touched on, some of which I'm going to reach for that stock answer. Well, time will tell, or we'll see, or it depends, because it really is such early days. But we could just run down those that we didn't touch on directly yet. And I'm happy to help do this, Jeff. If our starting at the top, the ones we skipped over, if our firms miss becoming a vendor of record for a particular trade, is there a way of being added to the list? That's not really being added to a vendor of record list is a whole other question, depending on the context of who the entity is. There are requirements under the procurement directive, both the management board one for government entities and the broader public sector, about running lists and how often they have to be refreshed. So it really is not so much about Buy Ontario in this case as it is kind of the context of the VOR. Now, let's just see here.
Glenn, I'm just going to interrupt. I think what we'll do is we'll cut off the questions at this point. And so if depending how long it takes to work through the existing questions, you might decide to cut that off too. But at least for the benefit of those people, if you please stop posting questions and we'll work through what we've got. And that would probably get us wrap this up in a reasonable amount of time. Because I think we could go on forever with this topic, I believe.
Yes, absolutely true. So the next question was, in the evaluative approach, can you please explain how the Canadian content would be considered? A bidder A has $100,000 price, 50%, 52% Ontario content, with a total of 55 Canadian content, and then another bidder has 48 plus 75 Canadian content. Does the Ontario heavy content get the discount? No, actually, although a lot of focus is put on the Ontario portion of Buy Ontario, the two get added together ultimately. So really, although the spotlight's on Ontario, the preference ends up being a combination of the two. So I think in the example of the 75% content, that would, I'm just pulling up the specific wording as we're talking here. I believe that would get the preference. Jeff, I don't know if you recall offhand. I'm just pulling it up exactly how it's worded. Under the evaluated, no, sorry, for the smaller evaluation, it's tricky. So for the under the threshold, the benefit goes to Ontario made goods and services. So somebody with more 55 would beat out, sorry, 52 would beat out 48 in the question on that front. And then for the other, it's apply 10% evaluation advantage to the bidder with the highest proportion of Ontario-made goods on Ontario services, followed by Canadian-made goods and Canadian services in the plan. So it seems like what followed by, on its face, it's a little unclear because as far as Ontario goes, in this very interesting example, the 52 beats the 48. But then if you take the Canadian into account, it flips, which is, of course, the point of the question, which is a great question. And I'm not sure that because the Ontario just narrowly beats out, it does for the higher level of procurement, because it was 100,000 was the price, that would be below the $350,000 threshold, and therefore it would be Ontario would win. At the higher level, I think you still need to take into account the Canadian. But I guess it'll require an interpretation to see. Anyways, let's go on. What level of a transparency will be made available to bidders post-evaluation? That's a very interesting question. There's an entitlement to debriefing, as you know, under the directives, the broader public sector directive, for example. And it may be that the answer that you would learn is that another bidder, the bidder one, had a greater degree of domestic content. So how much detail in terms of percentages, again, we'll see play out. Maybe guidance will come through one of the directives about the amount of disclosure of detail. We've got, but you can comply or explain why you can't. Will that be against you? Depending on the context, if you can't comply, then if it's, for example, the commitment approach, as I mentioned, you simply wouldn't be allowed to bid unless you meet the specified threshold. It's a version of non-compliance. It's no different than saying, can you give me a 50% performance bond? No, I can't give you one of those. Well, then you're not in. It'll be that clear. On the evaluative side, it doesn't, so long as there's some amount in your plan, that's fine. I guess in theory, you could have 1% Canadian content. But the bidders with the greater degree of content would be the ones that be evaluated more favorably and would win. The part is specified by the public entity and is manufactured elsewhere, but the purchase is from a Canadian distributor. What's the calculation for that? When you read the definition of Ontario goods, and for that matter, Canadian goods, it is where it's manufactured or produced. That's the key criterion. So if it's produced, manufactured, or produced in the US, but distributed in Canada, then that wouldn't count as a Ontario good or Canadian good. It's not the distribution. But the value of everything else about it, the markup, the labor, and so on, whatever's happening in Canada would be on the Canadian side, I guess. Now, what happens if material from Ontario is not available? You thought you're going to get a supply and something happens to it. This is a great question. And Jeff, you touched on it when you talked about contractual terms. And my concern about a system that says, here's the plan, it forms part of your contractual obligation and you're to meet it. Well, if some circumstances were to arise where you have to shift gears and source it from somewhere else, this particular item, you would then have to seek a contract change order to adjust your plan because now it's not achievable. And if there's penalties, I say penalties in air quotes, liquidated damages attached in some way, and I've seen this already, to the consequences of not meeting the plan, it just like schedule, you're going to be seeking an extension of the schedule. If circumstances arise, you're going to be seeking an adjustment to the plan if circumstances arise where it can't be met the way it was originally planned to. So that's going to be fun, to say the least.
Yes.
So then here's a comment about how to cope with all this. One way to help reduce the administrative burden on contractors is leverage support from their manufacturing partners. Suprema, for example, provides documentation on request required to demonstrate compliance, including proof of Canadian supplier status, Ontario presence, identification of products manufactured in Ontario in the format required. So, which is to say, people are saying, how on earth am I going to meet all of this stuff? There are resources available that help with all this. But again, that's going to be those kind of directories and information, kind of information that spec writers, of course, in a different context, very familiar with. I think that'll become more the norm, knowing where stuff is coming from. We note that there's no remedy action permitted to contractors yet. We've seen contracts for government entities that contain LDs on the percentage basis. Is that legal? And that, Jeff, you touched on that. There's a difference between the owner in contract with the contractor enforcing the contractor's commitment to meet their Buy Ontario thresholds that they've agreed to, versus somebody else saying, hey, that guy promised to do it and he's not doing it, or he lied, or whatever. It's the third party claim, the other bidder claim, I think that is an issue. But requiring the contract to meet its obligations is, I think, fair game, and it's something that we're going to see more of until it's challenged. I personally think an LD, a liquidated damages type clause, is going to create more problems than it's worth, but time will tell. I don't know if you have any thoughts, Jeff, on that. But
Yeah, well, that's just where I hope we get to a kind of a general market standard, in the relative near term, in terms of post bid contractual provisions, but we'll see.
So,
time to tell.
Yep, and so let's just keep going quickly. I'm not sure we'll get through all of them. We'll try. So we talked about the next one. What are the requirements on the procuring bodies regarding information provided to bidders for award? Will tenders be provided with evaluations indicating performance? Yeah, so the evaluative method, if that's chosen, it's spelled out and described in the procurement documents. And we've been helping owners incorporate language into their RFPs or their tender documents that talk about the process that they're going to be using to assess bids and the submission of the plan and what major goods are caught by it. So that is definitely what's happening. So there will be information in the bids. And as Jeff encouraged you, asking during the clarification period for clarification about things you don't follow or understand, I think is going to be important. And what level of transparency made to bidders post-evaluation? Oh, we touched on that, but the honesty. I suspect that bidders will be, who are concerned about some other bidder not actually being accurate, are going to be challenged getting to the bottom of that, because owners will say, look, as I said earlier, we're entitled to trust what the bidder said. We don't have to do homework. We don't have to look behind the attestation statement, according to the statute and directive and so on. And therefore, we thought it was all good. And the Supreme Court of Canada, in a case a number of years ago in a different context, but similar in nature, came to the conclusion there isn't that requirement to look behind what you're being told. So I don't think there'll be a lot of transparency there. If a major system or component fails, the emergency replacements required are the separate rules, meaning a flood or fire and so on. So I did mention that one of the exclusions or exceptions is if there's no source for it. And I think that I recall this, don't recall the specific language, but there is some recognition that when you have to act very quickly, and this is true in the directive too, that there's uh, sometimes you just have to look past the rules and you could make a case for not running through a whole process, requiring domestic supply chain information and evaluating it and so on. Look, we need somebody on site to deal with a crisis. That will be an exemption. And it's interesting because the last question I'll deal with, can you please provide comment further on the process to get an exemption? When you read the directive, it says that depending on the exemption we're talking about, and there's a variety of them, as I mentioned, the value for money exclusion and so on, or the unavailability of a product that other than, for example, a US-based product. You have to apply to either get the approval of the CEO of a broader public sector, or on the government side, a deputy minister level exemption. It's got to be a very high up exemption with a business case to be made, which then supports the audit that the government can undertake afterwards. So, but I do think in an emergency situation, you could make a case for it to get an exemption. There's a question about buying steel and if the source is a company in Ontario, do we have to note where they got the material from? Again, Ontario made goods or Canadian made goods is the key. It's not who you bought it from. You know, I bought it from Home Depot and they're just down the street, so that's okay, isn't it? Yeah, but if it all came from the US, then that's an issue. So it's really the source of it. So the answer is yes, you need to understand the source of the steel. And finally, will it be legal to enforce material or labor bond if the percentage of Ontario goods does not line up? Well, I think the question really is directed towards a performance bond. And is the contractor in default by not meeting the requirements? And that's the whole question we've touched on, the breach of contract for not meeting these requirements. As I said, predominantly it's all focused on the procurement side, but honoring the commitment throughout the project is the second stage. And the degree of what that looks like, what the damages are, is, I think, still an open question that's going to be developed. And whether it triggers bonding, the entitlement to default the contractor for not meeting the requirements and then calling on a bond to have a replacement contractor come in who does meet the requirements. I mean, that's a whole new world order we haven't traveled down yet, that's for sure.
Well, on behalf of those in attendance and the members of COCA and COCA itself, I just want to thank you and Glenn and Jeff so much for shining some light on what is a daunting topic with, as you pointed out, many question marks still out there. But I think you highlighted them and you sort of raised red flags, and now the onus shifts to the audience to sort of maintain an eye out for changes as they arise and developments. So thank you so much. I also want to thank Jeff McIntyre and his team at the Grand Valley Construction Association for doing the technical hosting of today's event. And lastly, I want to thank all those who attended. I think it was a very worthwhile presentation. And we're grateful that you made the time to join us today. So thank you very much, and goodbye, everyone.
Bye-bye. Thank you.
Bye.